our loopy isn't on, which doesn't matter because it's Sunday and I won't go anywhere. But I wonder if our speed is still at, yep, it is. So if you refresh, if you update your Google, YouTube will remember what speed you want to play the video at, but they will not remember to keep going with a playlist that you've been watching for 15 years and doing the same thing every single day. But that's okay. So, where are we at today? We are about to finish with this guy, Hope. He's still on the stand at the bitter end. So I don't know if we're going to finish. I suspect we're going to finish. However, maybe not, because we are on July 27th, part 1. And the next video actually is the last part of July 27th. And it's only 33 minutes long or something like that. I can't read it very well. So if we see him, he's only going to be around for like 30 some more minutes. And then he's gone. No way. And then he comes, I see another witness. And then he comes back. Of course he might. Of course he might. I think he might come back, but not today. Today we should be finished with him.
Are there any other people in this 200 to 400 member International Association of Bloodstain Analysts who have the title of distinguished member?
No, not at the present time.
Oh, now I got a new life goal. I want to join that club, guys. Call me Dexter. I want to join that club.
Now, have you authored any technical articles on forensic science?
Yes, I have quite a few.
Approximately how many?
I think my curriculum vitae says 95. I think it's well over 100 by now.
Have you authored any chapters in books or books themselves on the subject of forensic science?
Yes, I included those in the 100. Quite a few chapters.
Have you authored any books on the subject of blood stain interpretation?
Yes, I issued initially a report for the Department of Justice that was, I would call it a pamphlet, or being very kind, a booklet. It was only 77 pages, but it included the results of 2 years of research for the Law Enforcement Assistance Administration under the Department of Justice. And since then I have revised that, 1983, and most recently 1993. I completely rewrote the text, and it's now approximately 200 pages, I think perhaps a little more.
And has that textbook on bloodstain interpretation been translated into foreign languages?
Yes, I know it's been translated into Swedish, German, and Spanish. I'm not sure about French.
And do you know whether or not that textbook that you wrote on bloodstain interpretation is used by law enforcement agencies throughout the world?
I think so. That's why I get a lot of students.
Now, in addition to your writing and your publication of books on the subject of bloodstain interpretation, Professor McDonald, have you ever lectured on the subject of forensic science before any recognized professional organizations?
Yes, I have quite frequently.
And have you lectured on that same subject outside this country as well?
Oh, yes, many times in Australia, New Zealand, Europe in general, London, England, Scotland Yard, the United States, many states in the United States.
Sir, are you certified by any recognized forensic organization?
Yes, I'm certified as a senior crime scene analyst by the International Association for Identification.
And what is the International Association of Identification, sir?
It's the largest organization comprised of fingerprint identification technicians, photographers who go to crime scenes, people who would be involved in accident reconstruction or crime scene reconstruction, firearms identification experts, people that do question documents examination. It all has to do with identification in general, but it's more specifically fingerprinting in particular. It's a very large organization. It has membership all over the world.
Sir, have you ever received any awards in your particular field of forensic science?
Yes, I have.
Now, I'm asking you this one. Is there any particular award in the area of forensic science that you are particularly proud of?
Well, I'm always grateful and proud for all of them, but to say the most important, specifically in forensic?
Yes, in forensic science.
I would say the John Dondero Award, which is given by the International Association for Identification, which I received in 1974 in Washington, would be the one that I think is the one I hold most dear.
Is that award given out every year?
No, it's given when they feel someone should receive it.
And who was the first recipient of that award, sir?
John Edgar Hoover, the director then at the time, 1957. He was given the first one, He was director of the FBI at the time.
Now, you said you received it in 1974?
Yes.
Now, you've heard the names since you've become involved in this case of some of the experts who have become involved as well for both sides.
Yes, I have.
Are you aware of any other expert who's involved in this case who has also won the Dundero Award?
The only one that I know is involved is Dr. Henry Lee. If someone else has received it, I apologize to them because I did not check the list for that particular question.
Now, in particular, as a criminalist, sir, what experience have you had with human blood as evidence?
I began actually working with human blood during my master's thesis at the University of Rhode Island, where I effectively did what is now called immunoelectrophoresis. And in that process, we created many blood stains so we could analyze them. But in the process of creating them, we were aware of the geometry that results from different events, different angular impact, and so on. So I began then, but as far as studying the geometry specifically, that began in 1966 when I had a case that I knew the patterns told me something, but I just did not know what. So I began doing research the same way Dr. Petrowski did in Poland for the same reason. That was 1895. He did the same thing. He had a case he didn't understand. At least that's in his text. And so he did a lot of research too. It was not original with me. Many people have done this long before I did. I just was not aware of it. So I began actively working in 1966 and continued on, and I was asked in a meeting in Toronto in 1969 to apply for a grant from the government to pursue this specific subject of interpreting the geometry of bloodstains, the cause-effect relationship. And after I did that, and it was published and distributed worldwide by the Superintendent of Documents, I had a lot more research to do. People continually brought cases to us.
Now, Professor McDonald, you mentioned before something about an institute. Are you currently teaching, and have you been teaching for some period of time, the discipline known as human bloodstain interpretation?
Yes, as a direct result of the 1971 publication, it was called Flight Characteristics and Stain Patterns of Human Blood, I was asked first by the Law Enforcement Assistance Administration in Mississippi to come down and teach what I had written, and I did. In March 1973, I conducted what we call the first Bloodstain Institute. It was an institute on the physical significance of bloodstain patterns. It's a longer title. We refer to it as the Bloodstain Institute. And directly following that, in the spring of the next year, or later in the same year, and in the spring of the next year, there was a demand from students who wished to study with me on this subject. And to date, I've conducted 43 of these. We have another one scheduled in September. The last one was in Sweden at the National Police College in Sweden in May and June. The one in May was in Corning. The one in January was at the University of New Haven. We've run these in, I think, 13 states, the District of Columbia, and in Australia and in Sweden, and currently negotiating to run them in Denmark and Norway.
And generally, who are your students at these various institutes that you run in this country?
These would be mainly law enforcement personnel. They might be in a crime lab, a serologist, an evidence technician that would go to the crime scene. We have had many forensic pathologists attend. We've had lawyers. We've even had a veterinarian. So there's no restriction on who can apply, but they're welcome to come and learn. What they do with that knowledge, of course, is something else. I don't know what they will do.
Sir, in your capacity as a consulting criminalist, have you ever had occasion to present expert testimony on the subject of human bloodstained evidence interpretation?
Yes, I have.
Approximately, do you have any idea how many times, or at least in how many states?
On that particular subject, I would say conservatively 150 times in 32 states and 3 foreign countries.
And who generally retains you in these cases, sir?
Initially, I was retained by the prosecution more than the defense, and as I trained more and more prosecution, I won't say prosecution, I've trained more and more laboratory personnel who would be called by the prosecution. It's become less and less difficult for the prosecution to find their own expert and not call me. So currently I'm called less by the prosecution and more by the defense, but that is just the number of times I may be asked to investigate a case. It's not the number of times I testify by any stretch of the imagination.
By the way, Professor, you mentioned that in your very early work, back in 1954-55, you did something involving electrophoresis. Would that fall into the category of serology?
Yes, it would be serology, but that's the last contact I've had with serology, except for doing routine blood grouping tests on wet blood, not even on blood stains, so I'm not a serologist.
Okay. Could you explain briefly to the ladies and gentlemen of the jury the difference between serology and bloodstain evidence interpretation?
Serology is basically chemical reactions, serological reaction, immunological reactions, how one blood group reacts with another, or how blood clots and how it behaves in general. Bloodstain pattern interpretation is concerned only with the static aftermath. When blood is divided up into smaller and smaller spots or droplets that produce small spots. We're interested in the cause and effect relationship and knowing the size, the shape, the distribution of bloodstains of any size. We can generally determine the kind of activity that could have produced it. We can't say a specific activity did this, but we can more often than not say, this could not have done it, but here's 1, 2, 3, 4 things that could have done it. We study, as I said, size, shape, and distribution. Size will give you an idea of the energy available. Large drops, passive drops falling, there's no active energy other than gravity. If you have an impact from a beating or a stabbing, the viscosity and the surface tension of blood come into play. Surface tension is what holds blood together, like it does water or any other liquid. If you have energy to break the surface tension, it'll subdivide into smaller and smaller particles. If you have a lot of energy, like a gunshot impact, then you have sufficient energy to literally atomize mist or create a fog, a fine spray. It is very characteristic of high energy. Most often, gunshot, but not limited to gunshot. Hand grenades, bombs, other such things, airplane propellers will do the same thing. We've seen all of those. So the size gives you the energy, the shape gives you the directionality, which you can trace back usually to an origin. Knowing the ellipticity or the distortion of the circular spot, we can project the angle of impact back and estimate the origin, say above the floor or from a wall, based upon the shape. The distribution, the fanning out or dispersion, comes back to a common point of origin in 2 dimensions, which we then can convert to 3 dimensions. But it also involves the dispersion and concentration. The more concentrated the spots are, the closer you are to the origin. And then there are infinite numbers of transfer patterns from fingerprints, palm prints to tool marks, and your imagination can be the equivalent of putting something on an ink pad and transferring it to another surface. It doesn't matter whether it's an appendage of a human being or a knife blade or a ballpoint pen or a claw hammer. So
Professor McDonald, let me see if I can just simplify a little bit. There's been testimony in this case by a number of witnesses about conventional genetic markers and DNA genetic markers. Is that something that's in the field of serology?
Absolutely. I don't understand a bit of it.
Okay. And on the other hand, your work involves sort of actually analyzing bloodstain form, shapes, how they got there, that kind of thing, once they actually leave the body. Is that right?
That's correct. When the blood is out of the body, it's physics. When it's in the body, it's medicine.
Okay. And so you mentioned generally how many times you've testified as an expert. Have you also testified a number of times as an expert in this state, in California?
In this case?
No, in the state of
Oh,
California.
in the state of California. Yes, I have.
Okay. Do you know how many times you've testified approximately?
Yes, I have. I've testified 21 times. One was a hearing, and I think maybe 2 were hearings. They were in court. One was in court, one was not. But for the most part, they've been in a court of law.
And of those 21 times, do you know how many of them were for the prosecution? Were you an expert for the prosecution? And how many of those were you an expert for the defense?
I think 9 were from the prosecution, and that number varies because, to be fair, sometimes I testified more than once in the same case. Not the next day, but maybe a week or a month or a year later. So if you take the 3 times I testified, for example, in a case, if I call that a case, then the percentages vary a little bit. So it's anywhere from 40 to 47% for the prosecution and the difference for the defense.
Were you retained by Mr. Simpson's attorneys in this case, sir?
Yes, I was.
And approximately when were you retained?
In late August of 1994.
That's when you began consulting?
In this case, yeah.
Okay, that's what I meant. And since last August, how much have you been paid for your expertise, sir?
So far, I've received $10,500.
And that would cover since last August?
Well, it's not current. I've made 2 trips since then and done a few experiments, so it's really not up to date, but that is what I've been paid. That was your question.
Okay. Now, sir, in connection with your work in this case, did you, on April 2nd of 1995, conduct an examination of the socks, which are commonly referred to as item 13, socks recovered from the bedroom of Mr. Simpson?
Yes, I did.
And where did this examination occur, and who was present?
Well, I'd have to consult my notes to be sure of the names, but it was here in the Los Angeles area. It was at the Technical Associates Incorporated Forensic Laboratory in Altadena, California. And present were Dr. Henry Lee, Peter Newfield, Mark Taylor, and Greg Matheson.
And at that point, the person who actually brought the evidence to the laboratory, would that be Mr. Matheson from the
Yes,
Los
it
Angeles
was.
Police Department, SID Laboratory?
Correct.
And did Mr. Matheson actually unpackage that evidence for your inspection?
I'm not sure whether he did or Dr. Lee did, because I think it was done in more than one bag. He may have opened the first one, and Dr. Lee or Mark Scott Taylor may have opened the second one.
When you examined the socks on that occasion, April 2nd, did you specifically examine sock 13A, also known as sock 42A by Mr. Sims of the Department of Justice?
Yes, I did.
And when you examined that sock, did you specifically examine an ankle stain, which had already been DNA typed consistent with Nicole Brown Simpson?
Yes, I did.
And was that ankle stain, did it have a portion of it cut out?
Yes, there was a rather irregular area cut out that was basically rectangular with another rectangular appendage sort of on one side of the long dimension.
And were you able to see the remaining portion of that ankle stain with the naked eye?
Oh, yes, yes.
During the April 2nd examination with you and Dr. Henry Lee, did you use microscopes to assist you?
Yes, we used microscopes. I used my hand magnifier and high-intensity illumination. But we used microscopes, compound microscopes, stereobinocular microscopes to be specific.
And were photographs taken through the microscope that day?
Yes, the microscope Dr. Lee had a camera attachment, and we did take pictures.
And did you both look through each other's microscopes?
Yes, we alternated. If I found something that I thought Dr. Lee should see, I directed him to see what I'd just been observing, and vice versa.
And were photographs also taken without the aid of the microscope?
Yes, there were.
Now, sir, have you had an opportunity to review portions of the Department of Justice serologist Gary Sims' testimony in this case? Portions of it?
Yes, I've read it. I've read quite a few. I had to stop and think a moment which one that was. Yes.
Are you aware, sir, that Gary Sims testified that bloodstains on this sock may be spatter stains?
Yes, I am.
Citation, counsel. Citation.
Yeah, 1 second.
There's been no offer that he's used anything.
7726 is the description of
I
spatter.
want to show that to Ms. Clark, please.
Were you aware that Mr. Sims said that what he saw were spatter stains or something along those lines?
Yes.
All right. In your opinion, Professor McDonald, is the ankle stain that you saw a spatter stain?
Not based upon just what you've said or my examination. The examination,
Overruled. Overruled.
No.
not based upon the examination that I made of the socks at that time. I did not find any distribution of blood that I could consider a spatter. I've seen other more convincing evidence of it.
Okay. Now, with respect to the ankle stain, I want you to focus on that. In your opinion, was the ankle stain a spatter stain?
Oh, no, not the ankle stain. I thought you meant the entire stocking.
No, I'm focusing now on the ankle stain in particular.
Oh, the ankle stain was very large. It was not spattered.
Could-
That causes speculation. His witness only saw a hole with no stain that was cut off.
Overruled.
Professor McDonald, first of all, was there stain surrounding the perimeter of the hole that was cut out?
Yes, the cutout was taken out of the middle of the stain. It's the way you usually do it.
And are you aware that Mr. Sims has already testified that there was blood stain on the perimeter of that cutout area?
Yes, I am.
Could you please define what spatter is?
Spatter is simply the result of impact to usually a liquid. In this instance, we're discussing blood, and it creates a spray of small drops, not like gunshot, but it creates a spray, and that spray then is projected, and if it strikes a target, in the case of a target, I mean a surface that it hits, like it might hit the table or the tabletop or a wall. When it strikes that, when you see a sufficient number of small spots, you can determine that it is the result of an energy source consistent with a spattering, such as just clapping your hands if you had a liquid in your hands.
Now, you said that, in your opinion, the stain on the ankle was not a spatter pattern or a spatter.
No, it
Okay.
was very large. It was about 1 inch by 1.5 inches oval.
And in your opinion, sir, what type of stain was that blood stain?
That was a transfer pattern resulting from, I'm quite sure, but not positive, a compression transfer. A lateral or swiping action is the other possibility, but on the dark socks, I could not see any evidence of a feathering out on either side. So I conclude it has to be a compression transfer with no lateral movement sideways, or if any, extremely slight.
Now, when you say a compression movement, would that be consistent with a smear as opposed to a spatter?
Well, a smear generally, I think, is interpreted as having some kind of a lateral motion. Otherwise, it's just a drop or a pool. But it's not as consistent with a smear as it is just having blood on your hand or some object and touching it and pulling it away. For example, a fingerprint made with blood that's identifiable is not a swipe action or a smear, or it would not be identifiable. It is a direct compression and release.
Okay. You mentioned earlier that you and Dr. Lee took some photographs through the microscope that day. Is that correct?
Yes, it is.
Okay. This you've already seen.
Any second now we're going to talk about the murders in this trial. Any second, guys. I'm sure of it. I'm sure of it. I'm sure any second they're going to put on evidence about the murders in this trial and not about the way the tests were conducted.
I believe this will be defendant's 1276.
And what is it? Photograph?
It's a photograph, it's a photograph without the aid of a microscope of sock 13A,
Thank you.
showing the ankle stain.
Proceed.
Oh, like that. Now, you mentioned a moment ago, Professor McDonald, that when you looked at the stain around the outside of the cutout area, that you could tell that it was not the result of a spatter or splash on that sock. Is that correct?
That's correct.
And what was it about what you saw in that stain that led you to that conclusion?
It's really very simple. The stains that are produced by projection of any liquid will go between the fibers. If you had on, say, very heavy corduroy jeans or something, and you were to drop a drop of paint, it would go right between the fibers, and you would have a round, uniform stain. If you had paint on your fingers and wiped across it, or just touched it lightly, you would stain only the top part of the weave. So you would see dark ribs between the white paint. And that is the analogy that allows you to see whether blood is on the surface of a fiber or it's actually saturated and down through it. If you have enough, as in this case, enough blood to stain deeply enough, you will have it going through even though it is a transfer, except on the periphery, where it will show that there wasn't as much blood and it is more easily identified on the top of the fibers. So there again, we're looking at a two-dimensional representation of what we saw in a three-dimensional format with a stereo binocular microscope. Further, we could manipulate by rotating and tipping and so on the material we're examining. And in that way, we can see many things that cannot be reduced to a single depth of field where you are looking at the surface of an object. We had a great advantage doing it actually with the physical evidence above and beyond a simple photograph.
By the way, Professor McDonald, could you estimate about what percentage of that stain at the ankle is cut out in the picture and how much remains?
I'm just estimating the overall area from the extent of the stain as I see it, and then the cutout area. I would estimate that the cutout is perhaps 40%. I don't think it's half the amount that's there. And I say that because it's usually more difficult to estimate the peripheral concentration than it is the center. So I'd say about 40 to 50% maximum.
Okay. Now, you said a moment ago that the way you can distinguish between a splash of blood that dropped onto a sock as opposed to blood that is actually placed onto the sock by some other object is the way it actually appears on the fibers themselves. Is that right?
Yes, I have some samples either in my book or I brought color photographs of that if you think that description was not adequate.
Well, here's what I would like, sir. First of all, tell me, you
No,
said that you
no.
also took photographs with Dr. Lee that
We want you to pull out your crayons and just draw it. Please. Please draw the sock and the stains.
day with the aid of the microscope. Is that correct?
That is correct, yes.
I'll show you. This is 1277, Your Honor.
All right, this is a photograph from microscopy.
Photomicrograph? Photomicrograph.
Thank you.
Can I show you this picture, sir? Now, sir, is that photograph, do you recognize that photograph?
Yes, I do.
Okay. Is that photograph a fair and accurate representation of the way the stain appears when you look at it under the microscope on the outer surface just outside the area that's been cut out?
Yes, it is.
And may I please put this on the ammo?
Yes.
One moment. Now, Professor McDonald,
You fell
Would you please
right
explain-
into their trap. You fell right into their trap, Zach. It's a murder trial. You have to wonder who murdered the people. That's what you should be wondering.
what it is about this photograph that's taken of the outer surface of that sock and the perimeter just around the cutout area that indicates to you that this is a contact stain made by some object coming into contact with its sock as opposed to blood splashing onto the sock.
Yes, I think it's very clear that the staining, the darker red portion, which is blood, or reported to be blood, I did not do any presumptive tests on it even. The red area is just on the surface of the fibers and very non-uniform. There are many white voids. Now, I must explain, the white voids are the reflection of the black threads. It's very high illumination, intensity is high, and therefore, even though it's a black fiber, it reflects light and glistens the same way a black cat would glisten in the sun. So that is not a distortion other than by color. The red, however, absorbs the illumination and reflects more or less its accurate color, and you can see the many voids in it, particularly as the screen, as I see it, on the right about halfway up, there's a nice clear void that shows, and it's surrounded by red, and they're all over it. So that's what a transfer looks like. It's classic.
Could you, on the one that you have, sir, in front of you, you have markers, Your Honor, I believe?
Should be in the, there's one up here as well.
All right. Could you, using for contrast, could you please make a blue circle around what you regard as that upper surface of the fiber where the blood makes contact?
Well,
An example
that's
of-
all red. An example?
Yes. And sir, could you now, using the black marker, could you please circle for the, ladies and gentlemen, the jury, a portion of the sock which shows the area that doesn't get, I'm sorry, that is not in contact with the blood.
In one of the void surfaces.
One of the voids, thank you, Your Honor.
Not a very good black marker. It's coming out light blue.
One moment, please.
I'm all out of black markers. Mrs. Robertson, do you have any felt tip? Thank you. Professor,
Oh, I'm sorry. I thought I had one.
thank you.
Thank you.
And Professor McDonald, just so I understand it a little more clearly for myself, at least, what you're saying is that that what makes this kind of stain as opposed to a splash or spatter is that the blood is only hitting the upper portions of the fibers. Is that correct?
That's correct. The red areas are where blood is on the top of the fibers. The white area, if it had been projected, would be also stained. So it's just on the surface.
Sharpies change things.
A little bit more detail. May I pass these two around to the jury? They're identical. It'll save some time.
They are identical except for one has been marked and the other has not.
okay.
So no longer identical.
Fine. And I'll just pass, if I may, the one that
Yes.
is in line.
All right, if you'll hand that to juror number 1, please.
Excuse me, can I see where the witness is marked?
Certainly.
I bet you juror number 7 is holding on to it for a while, and that's what we're waiting on.
All right, the record should reflect that 1277 has been viewed by each member of the jury panel.
By the way, Professor McDonald, if two stains occupied the same, let's
Juror number 7's over there crying right now. They can't stop him from crying. He finally got to see a piece of evidence. He's so happy. Or she.
say dimensions. Do you know the approximate dimensions, by the way, of this stain that you saw on the ankle?
Yes, the overall stain before it was, well, even after it's cut out, my best estimate is about 1 by 1.5 inches. 1.5 inches running in this picture horizontally, and the 1 inch vertically, as you look at the picture, as I'm looking at it with the arrow facing up.
Okay. Now, assume for the moment that you have two stains of the same dimensions, each an inch by a half. One is the result of blood splashing in that area. The other is the result of this kind of contact with another object that you just described as occurring here. Which stain would actually have more blood in it if they occupy the same surface area?
The one that was added by, I would say, dripping. It's difficult to see how you would project a stain that size or a blood volume that large. Dripping blood would take considerably more.
Okay. And so, by the way, did you need Now, sir, are you familiar with Gary Sim's testimony that when he examined, well, let's go back 1 second.
All right, this is 1276 on the Elmo.
Thank you. First of all, can you point out, maybe it would be useful to use the pointer, what is the inner surface of the opposite side of this sock?
Why don't you hold on a second? Do you want to do that with a PowerPoint?
Okay, my lack of experience here makes me not the best qualified to do
No,
that.
I'm just saying,
but-
I mean, do you want the professor to do that with the superimposed
Oh.
arrow, or do you want
Fine.
to
Superimposed arrow is fine. You see where the arrow is, sir?
Yes.
Would that be characterized, that area, as the inner surface now of the opposite side of the sock?
Yes, it could be called that.
Now, are you familiar, sir, with Gary Sims' testimony that when he examined the inner surface of the opposite side of this ankle stain, he said, quote, there was no indication seen of soaking through to the other side, unquote. That's at page 27767 in the transcript. Were you aware that Mr. Sims said that?
Yes.
And, sir, are you familiar with Mr. Sims' testimony that the few reddish-brown specks he observed on this inner surface of the opposite side
Wait.
were merely
Wait. What did you just say? That was page 27767 of the transcripts. Oh no, I don't know what I just did there. I think I just rewound it by pressing 2. That was page 27767 of the transcripts. I think I did just rewind it 10 seconds. Sorry.
And reflects more or less its accurate color, and you can see the many voids in it, particularly as the screen, as I see it, on the right about halfway up, there's a nice clear void that shows, and it's surrounded by red, and they're all over it. So that's what a transfer looks like. It's classic.
Could you, on the one that you have, sir, in front of you, you have markers, Your Honor, I believe?
Should be in
Sugar. It's worse than 10 seconds. Ay.
There's one up here as well.
All right. Could you, using
We're not doing all that again.
blood splashing in that area,
That's good
the
enough.
other is the result of this kind of contact with another object that you just described as occurring here. Which stain would actually have more blood in it if they occupy the same surface area?
The one that was added by, I would say, dripping. It's difficult to see how you would project a stain that size or a blood volume that large. But dripping blood would take considerably more.
Okay. And so, by the way, did you need the brown specks he observed on this inner surface of the opposite side were merely powdered blood
Thank you,
that he
Malta.
believed had flaked
Thank
off
you.
the initial stain after it was already dry? Are you aware of that, sir?
Yes, I am.
Do you agree with Mr. Sims's conclusions?
Well, I can't disagree with what he has said about what he saw, but I saw things in addition to what he has said. He said he saw powdered blood, or powdered red material. He may have. I didn't see very much of that, but I did see some red spots that could be characterized as powdered blood. But to me, a powder is ground up. It's like fine sugar, powdered sugar, confectioner's sugar, as opposed to flakes. And I saw more of what you might call cornflakes compared to sugar, something like that.
When you looked through the microscope at the inner surface of the opposite side of the sock, did you see any evidence that the blood had actually soaked through to the other side of the sock?
Yes, I did.
Could you please tell the ladies and gentlemen of the jury what evidence you saw that led you to that conclusion?
I saw little balls of blood which were obviously wet.
Sustained.
Could you, without making a conclusion as to what the balls were, could you please describe them for the ladies and gentlemen of the jury?
I saw some small red balls that appeared to be a dried liquid. It was on some of the fibers on the inside of the opposite side. And some of these were photographed, one in particular. But again, it's impossible to see with a single photograph the different depths of focus, or depths of field, rather. So we had one that was
That's
particularly
wild and
good.
crazy breakfast.
Dr. Lee called my attention to it, and we photographed it. There were several.
Without reaching the conclusion of what they actually were, did these little red balls have the appearance of blood?
Yes, they certainly did.
And what about them gave the appearance of being blood on the inner surface of the opposite side of the sock?
They appeared to be the right color and give what I would call the right sheen or reflection. Blood has various characteristics, and one of them is its appearance under illumination, and whether it's transmitted or reflected.
Sustained. Answer stricken. Proceed.
Now, Professor McDonald, you said that you examined this inner surface of the opposite side of the sock under the microscope. Is that correct?
That's correct.
And when you examined it, were photographs taken?
Yes, they were.
1278.
Professor McDonald, I show you what has been marked as defendant's 1278. Do you recognize that photograph?
Yes, I do.
Is that blow-up a fair and accurate representation of what you observed under the microscope on April 2nd, 1995, when you looked at the inner surface of the opposite side of the sock?
Yes, it is.
Now, would it help to explain what you saw on the inner surface of the sock by showing that to the jury?
Well, it wouldn't help me. It might help them.
Okay. Your Honor, with the court's permission, may Professor McDonald stand up, because the photograph is only of a limited size, and if he holds it up from where he is, not everyone will be able to see it. I would ask that he be able to approach the jury.
Stand over to the podium. Professor McDonald over by the podium.
Just from here, do it, and then you can hold the picture up like a lecture.
This is greatly enlarged.
Can the court inquire whether everyone can see it first?
Well, what we're going to have to do is he's going to have to show it to various portions of the jury panel at different times because of the length of our jury box. Explain it once, and then you can re-point to the same location to the other jurors. But start there where you are, Professor.
These are many fibers constituting what you call a thread. And I think perhaps the best one that we photographed that shows a dried red fluid. It's round, and it's adhering to a fiber, which, in my opinion, is part of the thread. It's woven in. It is not dropped there. And this is high magnification. I don't know the exact magnification, but the smaller print was 70. I think this is perhaps well over 100 magnification. And that just shows a red area that is, in my opinion and conclusion, a fluid that is dried on this fiber, which, again, appears to be part of the thread. There are other red spots in this picture, but they're not in focus because it's a very narrow depth of focus, depth of field to be completely accurate, with a objective lens of probably 7 or 10 diameters. I don't know which one was the objective lens, but whichever one was the objective, the other, the ocular, was the converse. So one was 7 and one was 10 on that microscope. That gives us 70 magnification as we viewed it, and this is the picture taken through the microscope.
All right, Mr. McDonald, would you point to that red sphere and show the members of the jury to your right, please? To your right.
Your Honor, with the court's permission, I would ask that he actually make a green circle around that red sphere.
So I just want to make sure he points to it before it's marked so that all the jurors can see it before it's marked. Then we'll allow him to do that. All right, thank you, sir.
And with the court's permission,
Certainly.
thank you.
Mr. Newfellow, are you going to be marking many more of these? Are you going to be marking many more photographs?
No.
All right, the records reflect that Professor McDonald has placed a blue circle around what appears to be a red spherical object
Now,
on 1278.
that's good. Okay. Now, I'm calling your attention again to the Elmo, the overhead, Professor McDonald. Do you see what is the inner surface of the opposite side of the sock?
Yes, I do.
Okay. Can you describe, while you're holding up the large photo in front of you, what is actually being depicted in that photograph in terms of the weave of the fibers?
Well, right at the moment, the arrow on this screen is right on one of the fibers, which would be a thread that's vertical in this picture. And that would correspond to these very light areas on the large photograph.
Sorry, could you hold it up vertically so at least and point to
Well,
what you're describing to the jury?
The large white threads that are comprised of many fibers interwoven is shown where the arrow is right at the moment. It's almost to a dark line on the left, which would be between the threads. It's just the same thing.
Me
The
too, Maria.
inner
Me
surface
too.
is shown there, but at a much higher magnification.
And sir, with these red balls that you observed when you looked through the microscope, would they be readily observed with the naked eye?
Oh, no, you couldn't see these with the naked eye.
And sir, you said that you simply took this photograph to illustrate for the jury one of those red balls that looks like blood. My
Yes.
question is, when you looked through the microscope, did you see many more of those red-like balls?
I saw perhaps 6 or 7 that I would say appeared like this, that were round. There were other red, I would call them flakes, or if you like, powder, that were not, in my opinion, bonded to the fibers. But the ones that were bonded would indicate to me that whatever it was that had bonded was wet at the time it dried.
And when you say, and when you say, sir, that you saw 6 or 7 of those rounded red liquid balls that had the appearance of blood that were bonded to the material, was that from a search of the entire inner area of that cut, or was it from a very small area within that inner surface of the opposite side?
First, it wasn't liquid. It had been liquid. But it's impossible to tell where this photograph was taken other than it was within the cutout area. I saw several of them, and obviously this is the best one that Dr. Lee and I saw together, and it's the one that he photographed. He took some other photographs, but this, I think, depicts most clearly what we saw.
Now, sir, you said a moment ago that, well, withdrawing, seeing these bonded drops as opposed to those flakes that you were describing, what does that tell you about the condition of those red balls at the time they first made contact with the inner surface of the opposite side of the sock? In other words, were they wet or were they dry?
They were fluid, and like fluids, they formed a ball because that's the lowest surface area to any geometric figure, and that is why in air, blood, rain, any liquid is round. It is not teardrop shaped. It's erroneous to show a teardrop to depict perspiration, blood drops, anything. Artists do that, and we are conditioned that that's what we're supposed to think of as a liquid in the air, like rain. It does not look like that. It's round. And because it has this cohesive force to pull it together, when it's bonded to something, a wet something, I should say, such as this red liquid has done, it will tend to ball up, very much like a drop of water on the hood of a car that's been waxed. It looks like it's a ball sitting there rather than spreading out. It does not wet the surface. So when given the chance, a liquid will pull together in the shape of a sphere or a ball. And so this was a liquid before it dried.
Now, sir, having observed these different balls of red liquid that appeared to, that looked like blood, bonded to the inner surface of the opposite side of the sock, what conclusion did you make about whether the ankle was in or outside that sock at the time the transfer occurred?
Sustained.
Sir, were you able, based on your observations of your microscopic examination of this sock, to reach an opinion as to at what point those liquid balls were transferred to the inner surface of the other side of the sock?
Sustained. Let me see counsel over the sidebar without the court reporter, please.
Just let Newfield testify. Quit being mean to him. Just let him testify. It's not a problem. It's not a problem. Okay, that takes us to the end. Oh, wait. We want to see him say no more questions, right? That's what we're waiting for. The next video is also
don't we-
very short. And the
Why don't we
next
take
one
our
is
break at
short.
this point, since we lost one of our jurors here?
Juror 7.
Oh, we're back. Okay, ladies and gentlemen, we're going to take our lunchtime recess. Please remember all my admonitions to you. Don't discuss the case amongst yourselves.
Oh,
Don't form any
lunch
opinions about the
sounds
case. Don't
delicious
conduct any
right
deliberations
about
until the matter
now.
has been submitted to you. Do not allow anybody
even
to
care what it
converse with
is.
you with regard to the case. And we will stand in recess until 1:15. Professor McDonald, you're ordered to come back at 1:15. All right? We're in recess.
All right.
All right. All right, we have 3 matters to take up at this point. The motion to reconsider, the Reichart motion, discovery issue regarding the gloves And I understand and a few scheduling matters. All right, Mr. Douglas, good
Your Honor,
morning.
good morning. I'd like to argue the motion that we filed, which is our motion to allow Mr. Simpson to exercise his constitutional right to present a defense. Your Honor, I think that given this court's inherent broad discretion to control the administration of evidence, that there's little question that the court has the ability to hear this matter at this time. I think that a review of the totality of the evidence that is currently in evidence shows that there is very slight evidence that Mr. Simpson had a motive to commit these crimes. And I think that, as far as I can recall, the only evidence of motive that we've been privy to in this case is some theory that the death of Nicole Brown Simpson was in some way a final act of control that Mr. Simpson chose to exercise.
He's got a point there.
Sharing a hamburger at McDonald's with Mr. Kalin. Since, Your Honor, there is only slight circumstantial evidence in the record supporting that theory.
It's not in the record. Wait, stop, time out. Everything, okay, we heard a little bit about McDonald's, a little bit during the trial. But everything we heard about McDonald's and what OJ said and anger and all that, that was the preliminary hearing. Like, during the trial, they barely touched it. So he's right. He's got a huge point there.
I think that Mr. Simpson should be permitted to introduce evidence of another possible motive, which is every bit as plausible and every bit as compelling as that which the jury has already been permitted to hear. Your Honor, I don't want to take up the court's time to recount verbatim the offer of proof that Mr. Cochran offered when this matter was heard perhaps 10 days ago. But I do think that when you consider and when you weigh the evidence of motive that is currently in the record, that it is apparent that we're not talking about a People versus Hall matter. That is, we are not trying to offer circumstantial evidence that there were certain unknown third parties who were identified who may, in fact, have been responsible to commit these dastardly crimes. But rather, I think that we should be given latitude to rebut the current inference in the record, that the only motive that the jury has been allowed to hear that anyone in this world of ours would have to have committed these crimes is this slight circumstantial evidence that Mr. Simpson was carrying out some final act of control. I think, Your Honor, given the facts that Detective Lang has already admitted to, given the fact that there is little question that Ms. Resnick was involved in drugs in the days preceding the murder of Nicole Brown Simpson, given the fact that it is beyond dispute that there was an intervention that took place where her close friends gathered to confront her with her drug involvement, that certainly there is every bit as plausible and as compelling another motive. Certainly there is evidence that should be offered and allowed to be introduced to rebut the thin strands that are now in front of the jury, suggesting that the only possible reason why this crime could have been committed was because of some act of control. I think, Your Honor, that it's important to weigh the state of the record. I think that there can be reasonable limits placed on the extent of Mr. Reichardt's testimony, but I do think, Your Honor, that there is sufficient basis for the court to exercise its discretion to allow for the introduction of his testimony.
What limits would you suggest when you say certain limits?
I think, Your Honor, that it would be permissible that Mr. Reichardt can discuss the nature of his past relationship with her, reasons why he believes she was using drugs, reasons why he believes that she was no longer welcomed in his home, and the dates of that, the circumstances of the intervention that occurred, certain reasons why he believes, in fact, that she was using cocaine and how it was discovered and how he happened to see it. I do not think, and I can appreciate the court ruling, that he would not be allowed to testify concerning any theory that there were Colombian hitmen or any theory that she owed money, a particular sum to a particular person.
But isn't that the basis? I mean, isn't that a fundamental part that's sort of missing in the offer of proof, that she owed money, a substantial amount of money that would cause this act to occur?
I think, Your Honor, that there is circumstantial evidence that can be permitted and that is admissible that would allow for an adequate inference of that, because she was not gainfully employed at the time. She was not receiving any support from Christian Reichert. He will testify to those two things. She was using drugs. She was using drugs to such an extent that her dearest friends saw the need to confront her. She was placed into a drug program. I think, Your Honor, that
I mean, your offer does not include any information regarding the amount of drugs we're talking about here.
My offer does not include any information as to the amount of drugs. My offer does not include any information as to precisely whom the drugs were purchased from, the nature of the consignment, if at all, the nature of those arrangements. Correct.
Okay.
But I do think, Your Honor, that given the contrary state of the evidence, given what I suggest to be the far from compelling evidence of motive, and I recognize that motive is not an element of the case that must be proven, but given that which the court has allowed to be introduced, that in fairness, there should be some room for balance, there should be some room for some latitude, and I'm asking for a limited window to allow certain pieces of evidence. Perhaps the circumstances, Your Honor, the fact that there was an intervention days before, 5 days before the death, I think is important evidence. I think it is compelling evidence. Perhaps the court would not allow Mr. Reichert to talk about the reasons why he saw fit to sleep with a gun in his bed because he feared that there'd be drug killers looking for him. I can understand if the court wanted to put limits on that regard. But I do think that in reason and with some consideration that the court can fashion a narrow, appropriate window that adequately enables the defense to rebut. And again, the crux of my argument is that we seek to rebut that which the jury has been allowed to hear thus far.
Thank you, Ms. Bennett. Ms. Lewis.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, there is no basis for a motion to reconsider here. In the civil arena, a statute requires that even for a motion to reconsider to be brought, it requires newly discovered facts and a reason and explanation why the proponent of the evidence didn't discover those facts before. There's no formal provision even for that in the criminal law, though if there was something vastly different and analogous to what the Code of Civil Procedure requires, I'm sure the court would hear it. In this situation, Mr. Cochran made lengthy offers of proof to the court, in chambers apparently, which I was not present to hear, as well as out here in open court on the record. The court issued a very detailed, considered ruling on this issue, and there's simply no reason to change it now. What Mr. Douglas tries to argue is that it would just go to rebut this narrow portion of the people's case, and that is motive evidence, but he concedes we need not prove motive in any murder case to the jury, though evidence may be admitted for them to consider, and we have admitted evidence here. But whenever you're talking about the possibility of some third party committing the crime, you are talking about the defense seeking to rebut some portion of the prosecution's case, whether it's motive or other evidence of identity. So there's nothing novel in his argument. He's just saying we want to use it for this purpose, which is just one of the purposes that third-party culpability case law addresses. The court is on very, very, as you know, solid legal ground in this ruling, and I submit would almost be an abuse of discretion to do otherwise, to allow in evidence here. Because, Judge, one of the important things that I want to make sure is understood, even if there was evidence, and there has never been an offer from the defense that there is any evidence, but even if there was evidence that Faye Resnick owed a drug supplier money, that is mere motive evidence. And that's not enough to link somebody to the actual perpetration of the crime, which is what Hall and those other cases require. So even if they did come up to that level, which they don't, that's what the case law says is not enough. There has to be a direct evidentiary link, not mere motive in a third party. And if they had an identified party, which they don't, and they concede that they don't, and seem to think it works in their favor, it works against them because they've not even identified a third party. But even if they had an identified third party, and they had evidence that she owed that third party drug seller perhaps money, that all of that is just motive evidence. That's still not the evidentiary link that Hall and the case law coming after it throughout the 1990s require. So number one, there's no basis for a motion to reconsider. If the court is indeed, for technical reasons, granting the motion to reconsider and reconsidering its ruling, there's been nothing in the offer of proof or in the argument of counsel for the court to change its ruling. And there's been notably a notable absence of any case law cited this morning by the defense in this attempt as well.
Briefly.
There certainly, Your Honor, are broader areas that the defense could seek to offer through Mr. Reichert.
Don't call her broad.
That would be able to more closely track the quality of the proof that has been offered by the people. But I think when the court considers the context of our motion, it's fair to compare it with that which has already been allowed to be introduced. Your Honor, we don't want to use Christian Reichert to talk about the frequency with which Faye Resnick and others in Nicole Brown Simpson would go out, would use drugs, and would party, and how Mr. Simpson was never a part of that. or the reasons why Mr. Reichert would believe that Mr. Simpson was not trying to control Ms. Brown Simpson in the days before the murder, or the nature and the circumstances of the relationship between Mr. Simpson and his ex-wife in the months and the weeks before, which would all point directly against a claim that Mr. Simpson was trying to control Nicole Brown Simpson, particularly, Your Honor, as it came to the more relevant times, that is, the days and the weeks before the murder. But we do think, Your Honor, that given the evidence that has been allowed to be introduced, given, for example, that the court has found it relevant that a 1989 incident would suggest that Mr. Simpson has a certain mindset such that he is capable of committing the crime in June of '94, given the state of the record that certain other things that occurred in '93 are relevant to what happened on June the 12th of '94, we believe strongly that Mr. Simpson should be allowed, narrowly if the court chooses to exercise its discretion, carving out a niche. But I do think that there is adequate bases and adequate grounds, given the current record, to allow for some introduction of facts that are germane, that are pointed, and that directly contradict the theory that the jury is currently left with, that there's only one possible motive, and that motive is that Mr. Simpson was exercising a final act of control. That's not the way that the evidence should be. That's not the way that a fair jury should be allowed to consider. If we are talking about a search for truth and having the jury fully apprised of everything that was really going on at 875 South Bundy, we think that the exercise of fairness should allow for the introduction of this evidence.
All right, thank you, counsel. All right, counsel, I need to review one or two cases before I rule on this matter, and I'll issue a ruling on Monday. All right. The discovery matter on glove photos. Mr. Neufeld, do you want to address that? Good morning.
Your Honor, I believe, as you already know, the prosecution has obtained in the course of their investigation photographs of Mr. Simpson depicted in his professional capacity covering certain football games wearing leather gloves. We will take the position, obviously, that those pictures are completely irrelevant, but that's not even the issue at this time. The issue at this time is one of discovery. So far, all we've received are photocopies from the prosecution of those actual photographs. The photocopies, unfortunately, are relatively illegible, especially when you're looking for the kind of detail that one would expect to want to look at of a photograph of Mr. Simpson wearing gloves. They are arguing that this is relevant evidence. If it is relevant evidence, it is a photograph of Mr. Simpson, it is real evidence. The statute is unequivocal on this point. In 1054.1, when it talks about what is discoverable and what must be turned over to the defense, it states under subsection C, all relevant real evidence seized or obtained as a part of the investigation of the offenses charged. Okay? You can look at McCormick, you can look at any textbook at all on the meaning of real evidence, and I'm sure Your Honor appreciates a photograph of Mr. Simpson would be real evidence. There's no question about that. It's not limited to evidence seized, it also includes evidence obtained in the course of their investigation. The only other limitation is it has to be relevant. Well, they're alleging or asserting that it's relevant. If they're asserting it's relevant and they want to use it at some point during these proceedings, whether it be for impeachment purposes or any other purposes, since they did obtain it in the course of their investigation, we are entitled to receive it as discovery early on. Not after a witness not after a witness completes his direct testimony. It's part of the discovery statute. And for that simple reason alone, we're entitled to see those pictures. Frankly, we need to see those pictures anyway so we can better argue why it would not be relevant for purposes of impeachment or for direct evidence or rebuttal evidence or any other evidence in this case. But to turn over certainly only Xerox copies when that has not been the procedure in this case, when in every instance where we wanted to introduce photographs, we turned over as discovery in advance, not photocopies of those photographs, but actual prints. And in all other instances, to my knowledge, the people have done the same.
Zach, are you still here? Because I have questions. Real quick, he just made me think of a question. I was watching a case on Zach's channel. I'll get the link. Yesterday. And what the judge was saying is you cannot impeach your own witness. But hold on, I'm just getting his link for you real quick. What do you mean you can't impeach your own witness? So let's just say in this trial, the prosecution put a witness on the stand. Let's just say Furman. They put a witness on the stand, and that witness lied or said something that was not true. Right? The prosecution can't call another witness then to impeach Furman. They can't put evidence up to impeach Furman. Not that they did. This is a hypothetical. This is just something I saw on one of Zach's videos yesterday, because I love watching his videos. I learn a lot.
This is the only instance I'm aware of where they've limited the reproduction to photocopies. And it's fundamentally unfair. It's outside the statute. And I think that the court at this time should order them to turn those photographs over forthwith.
Ms. Willis?
Your Honor, it's nice to cite the discovery statute, but when the California Supreme Court in 1991 directly addressed this issue, which defense seeks to raise, it's more appropriate to cite their holding in Izazaga versus Superior Court at 54 Cal 3rd. I know the court knows the case, but for the record, 356, at pages 376 to 377, the defense protested because they felt that due process required that the prosecution disclose not only rebuttal witnesses and their statements, but other evidence gleaned in rebuttal to the defense case. And they say that. And what the California Supreme Court holds is that the due process clause does not require such disclosure. It says that the court says at page 377 that the witnesses and their statements are what is disclosable, defense witnesses for prosecution witnesses, and nothing more. We glean nothing from the Supreme Court's interpretation, talking they are about the U.S. Supreme Court, of the Due Process Clause to lead us to conclude that reciprocity requires the prosecutor to disclose other evidence gathered in response to a compelled defense disclosure that may be used to refute the defendant's case, when the defense is not required to do so, do the same following discovery of the prosecution's witnesses. So it's directly on point. It's directly on point. It's a holding of our California Supreme Court construing the relevant statute, and the court is duty bound to follow it. This is relevant, real evidence which we are using in rebuttal. We're in a different ball of wax when we talk about the people's prosecution case in chief and the people's rebuttal, and this is rebuttal.
Haven't we sort of gone beyond that by actually disclosing to the defense by means of photocopies of these photos what it is?
Well, the defense benefited. They got a windfall with that because during our case in chief, we were considering the possibility of putting on witnesses with regard to authenticate and so forth those photos. We were considering doing that, though we never actually made the decision to do that. But because we've been so generous in discovery in this case to the defense, we went ahead and did that. But that was at a time we were considering putting it on in our case in chief. We never decided to do that, and we in fact did not do that, and we have rested, and we're into the defense case. So that equivocal nature of our decision on that part benefited the defense. They got the windfall of that, so they were not entitled to those Xeroxes even then.
How many photos do we have? Are we speaking of?
May I have a moment? Your Honor, Mr. Darden reminds me as well that there are some photographs that were obtained during our case in chief, which I just alluded to. There are also photographs that have come in and we've obtained since the defense started their case. Altogether, there may be as many as possibly 15 such photographs. And videotapes as well. But, Your Honor, the Supreme Court is clear that this is evidence that need not be disclosed to the defense, that the prosecution is using in rebuttal. And counsel has not made the argument and has not even cited a case for the proposition that there is any waiver. What they did was to get a windfall by that early partial disclosure.
Right. How many photocopied photographs did you actually turn over to the defense?
They may be in a better position to tell us how many they have.
Your Honor, I'm informed by Mr. Douglas that it's approximately 8, and he's only estimating, he doesn't have it in front
Are
of him.
these a variety of photographs or photographs of the same thing?
No, they're different. Xerox copies of 8 different photographs, not of the same. They're not different photocopies of the same thing.
I think there are different occasions, if that's what the court is asking, for the most part, not 15 different
I'm obviously
occasions.
not making myself very clear this
I'm
morning.
sorry.
All right.
There's a variety of occasions. I don't think that there's 15 occasions, but there's more than one, I believe.
All right. Any other argument, comment on that?
Yes, Your Honor. Just very, very briefly, this so-called equivocal act by the prosecution is commonly referred to as a waiver, I believe. I don't think I need to cite case authority for that. If they gave over part of a statement or a statement in one form, I think they'd be obliged to turn over the actual statement that they had. Look, the most important thing here also is not just that I think we're entitled to it under the discovery statute, but if you think about it, they're going to try and suggest that they can use these photographs for impeachment. We will argue that they are actually irrelevant and it would be inappropriate impeachment. We'll be in a much better position to not waste the court's time and argue that effectively and efficiently if we can actually see the photographs and the details in those photographs as opposed to relying on Xeroxes to explain why, based on other evidence we have, they are completely irrelevant. So if they show us the photographs at that time, we'll then have to have a recess so we can look at other matters. It makes absolutely no sense in terms of the court's, in terms of judicial economy or efficiency of these proceedings. There's no reason for this kind of sandbagging.
All right. Thank you, counsel. Sure. All right, I'm going to order the prosecution to disclose and make available for examination the actual photographs of which they have already provided Xerox copies to the defense.
There's also ruling on the videotapes, because you made an earlier ruling that all videotapes that came into the possession of the prosecution would...
No, counsel, it's just the ones, the photocopy. If they've given you a photocopy, they have to make available to you the actual photographs for your examination. If it's something else that they've garnered in preparation for rebutting your case, they're not required to disclose that at this time.
Thank you.
All right. And I think that's it at this point. Mr. Douglas.
We spoke briefly in chambers about our interest again to introduce defense exhibits. I've explained on other occasions why I'd like to do that now. I'm informed that although the prosecution has been given our list since last Friday, I believe, that they're not prepared to handle that today. I would ask that they be directed to prepare to work on that early next week. I'd like to do it on Monday if the court pleases.
All right, well, Mondays I don't think is a reasonable request given our other schedule motions. Mr. Darden, when do you think you'll be prepared to address those issues?
Thursday or Friday, Your Honor.
Okay.
There's the Furman issue. We received a letter from counsel saying that they want Detective Furman in this on Tuesday, plus there are other issues.
I did have an opportunity to talk to Mr. Darden about that. I had a conversation with Mr. Douglas that because the North Carolina judge has denied, however you phrase it, the certificate of materiality with regard to the those tapes, Mr. Douglas had informed me earlier that they no longer, unless that ruling changes somehow, I intend to call Detective Furman next week. And I did inform Mr. Douglas that Detective Furman is back up. He's at home now, which is in northern state from here.
Your Honor, I had the occasion to speak with Mr. Cochran briefly. He told me that he had a chance to listen to the tapes, that there was Furman's voice on the tapes, that the tapes were disgusting in some of the language that was used, that there was discussions of ways in which Mr. Furman and others would implicate innocent people, and that we intend to vigorously appeal a ruling that we are confused by. We thought and we were hopeful that we would be able to present that very compelling evidence to this jury with Mr. Furman on Monday. Because of this unusual ruling, it will be necessary for us to take some appellate remedies immediately, so I do not think that he'll be called on Monday, but I do think it will be sooner rather than later.
Well, he's on 72-hour call from Idaho, but I do want to mention he's retired as of August 4th, and when he was first mentioned within a letter we got from the defense, he came down here. He was here for at least a week, I think maybe 2 weeks. He took care of his retirement. He was available. If indeed there's a good reason and the court allows him to be recalled for some reason later, I'm assuming the defense would send him a plane ticket because he lives in Idaho now.
All right, well, we'll take that up when the materiality has been determined. All right, anything else?
We don't have to do this on the record. I asked Mr. Clark, I understand, is in the building, and I have the Xeroxes of the charts. And I think there's a few matters we could discuss and maybe resolve.
All right, is Mr. Clark available?
Oh, yes, he is. I'm surprised he's not down here, as a matter of fact.
All right, well, why don't you have him wander down, and perhaps Mr. Scheck, Mr. Clark, and myself can confer in chambers on these matters and perhaps save some time for next week. All right, anything else?
Just, Your Honor, do you wish to deal with scheduling on the record, or do you want to discuss that informally after we recess?
No, we can just discuss that informally. I think, well, Monday we have the disclosure motions, and you have your witnesses subpoenaed for Monday?
Yes, Your Honor. It's going, what we're going to do, just so everybody's aware of it, is, as you know, Dr. Reed had to leave and will not be able to be around for Monday, so we will go forward with Professor McDonald, finish him on Monday, and we will have Dr. Reeders testify and complete his cross-examination when he returns from Vienna with his family.
All right.
So they
Also,
both
let
come
me,
back,
return to
both
Mr.
of
Douglas,
them.
the videotape.
We haven't
Mr.
heard enough
Corrado
yet
that you
from
submitted
them.
to the court's viewing. And I did direct Mr. Shapiro to make one deletion from the videotape, a sustained objection. All right.
Your Honor, I assume, well, I can discuss this with Mr. Douglas. I assume he has the photocopies here so that we could identify, we may well have already put discovery numbers on them, but I'm not sure if that was part of our formal discovery in terms of which photographs we need to show.
Okay. All right, anything else? All right, then we'll stand in recess until Monday, 9 o'clock. All right, thank you.
All right, this next video is just long enough to make it to the end of this stream, I think.
pretty straightforward. There's a statute right in the discovery statutes which accepts law enforcement investigation, which I failed to cite to the court last week, that I believe is dispositive along with the recent second district case. I don't think it'll take the court forever to decide this, frankly.
All right. It looks to me, because of some of the medical appointments that we will have to make adjustments for, we will have room on our calendar in our court day to take these up. But let me see how long we run with this shield law business
Okay, great.
before we make that determination. All right. Dean Allman, you want to go first on this?
Yes, Your Honor. We would like to
We actually have a number of sub-issues here. I note that we have a motion to quash a subpoena ducis tecum. We have a motion to quash a subpoena on Tracy Savage, and we have a number of other sub-issues in that category. So how do you suggest we proceed, first of all?
Well, we suggest calling Tracy Savage to the witness stand to see if she declines to reveal the source, and we will then proceed with a showing of why the qualified privilege should be overcome in this case. Privilege is a misnomer. Why the assertion of immunity should be overcome in this case.
All right.
I don't believe the assertion of the immunity is grounds to quash the subpoena, but if Your Honor wishes to hear argument on the motion to quash the subpoena before we put Ms. Savage on the stand.
I think that's what it comes first, logically.
All right.
All right. Let me ask, who's going to represent the people on this matter?
I will, Your Honor.
All right. Do you have any position regarding the motions to quash the subpoenas on KNBC, the subpoena DT, and the motion to quash the subpoena on Tracy Savage?
Well, Your Honor, we don't have a position per se as to some of the issues because they involve policy concerns that don't directly involve the people. However, one of the prongs of the three-prong test that the court would rule under Delaney versus Superior Court has to do with the materiality of the evidence, and obviously we have a very strong interest in how Your Honor would rule on that, because ultimately it would affect the court's decision if there was any information that resulted from these inquiries. It would affect
That's
whether or
an
not
issue
Your
I
Honor
wanna
was
get to
going to...
if I deny the motions to quash the subpoenas.
If you deny the motions, that's right. But there's a question here as to placing the cart before the horse, because it seems to me that this is a primary threshold issue that the court would have to concern itself with prior to making the decision as to whether or not it was going to quash the subpoena.
All right. Ms. Edgerton. Good morning, counsel. Do you want to approach and make your appearance for the record? I guess the ball is in your court then, because what I'll entertain at this point is a motion to quash the subpoenas, both the SDT and the subpoena for Tracy Savage.
Your Honor, Kelly Sager is going to address the motion to quash with respect to Ms. Savage. As the court knows, our motion on the SDT is basically just a sort of tag along on that, which I would be happy to address after Ms. Sager is on.
All right.
Thank you.
Good morning, Your Honor.
Good morning, Ms. Sager.
Kelly Sager, appearing on behalf of Tracy Savage, who's a reporter for KNBC Television. As the court has indicated already on the record, with me today are Ann Edgerton and Patricia Duncan, who are in-house counsel for KNBC. And we have filed a motion that I understand the court has received and reviewed to quash the subpoenas directed to Ms. Savage on two grounds. That is, we understand that the only two things that the defense is seeking from Ms. Savage are to reveal her confidential sources, which we think is protected under the First Amendment, the California Constitution, California Evidence Code, and to the extent that they are seeking to have her authenticate tapes that were broadcast by KNBC, that she is not the appropriate person to do that, that a custodial declaration or a custodian of records who actually keeps the broadcast footage would be a more appropriate person to testify. So neither of the two things which the defense seeks to have Ms. Savage testify about are appropriate, and that's why the subpoena should be quashed. If I could just start with a premise that in California, the shield law protecting reporters from having to reveal confidential sources has existed, at least in statutory form, for more than 60 years. And 15 years ago, the California voters elevated that provision to a constitutional provision. And California courts have recognized that by doing so, the voters intended, as the legislature had previously indicated, to indicate that this was a very important principle under California law. And in fact, that it was to be given the highest possible protection, which becomes important when the defense attempts to compare the California shield law protections to other protections that are given statutory protection. The leading case, is clear, is Delaney versus Superior Court, which, although the circumstances there were very, very different from the circumstances in this case, at least laid out factors that the court is to consider in making a determination in a case involving a criminal defendant who's attempting to seek information from a reporter. And as Mr. Goldberg indicated correctly, there is a threshold issue that the court must reach before it engages in any kind of balancing equation. The defendant has the burden of proving that there is a reasonable possibility that the information that they are seeking will materially assist the defendant in his case. And if this threshold inquiry is not met, The court's inquiry stops. It need not reach any of the other factors or engage in any balancing analysis. The language is important. Although the defense has suggested that this is an easy threshold to meet, in fact, it is not. It must be a reasonable possibility first, not merely any possibility that the information will assist the defendant. And the Delaney court specifically said it must go beyond mere speculation or conjecture or some hypothesis about how this information might affect the defendant's case. That goes to the likelihood of the information being useful. But there's a second prong. It must materially assist the defendant's case. So it must be significant information to the defendant's case, not merely any information that has a potential of affecting their defense. And if you even look in a dictionary, Webster's defines material as, quote, having real importance or great consequence. So even if the Delaney court indicated the information doesn't necessarily need to exonerate the criminal defendant, it has to be something more than merely tangential or peripheral information. It implies some sort of direct proof of an important issue in the case. Neither of these two parts are met in this case, let alone both of them. It certainly, as I understand the defense's theory, this information is sought simply for the purpose of establishing some possibility that there might have been some conspiracy to frame the defendant with respect to the planting of blood on the socks found in Mr. Simpson's bedroom. The identity of the sources of a KNBC News report broadcast in September is certainly not direct evidence of any conspiracy. And in fact, as Mr. Goldberg argued, I thought quite persuasively last Thursday, it's counterintuitive that someone who is engaging in a conspiracy would run out and the first thing they do before the conspiracy has even been affected is tell a reporter, oh, here's what we've done. Why reveal that information for public dissemination on a date when the testing simply had not been done, if that in fact is the case? It's counterintuitive that someone engaged in a conspiracy or who knew about the conspiracy would have done that. But moreover, it's not even indirect evidence of a conspiracy. And the defendant's argument here is incredibly attenuated, that someone who was involved in some kind of conspiracy would have told a news reporter about tests so that they would know that the tests, which had not yet been conducted, according to the evidence presented in court, were going to reveal something that had not yet occurred. Any other explanation for how this information came to Ms. Savage is far more reasonable than the attenuated link of factor upon hypothesis upon speculation that the defense would like to use it for. The sources may well, as Mr. Goldberg suggested, have simply mistook the PGM subtype testing for DNA testing, which, as Mr. Goldberg indicated, does have an element of genetic markers, and someone revealing that information might have mistook that to mean genetic testing as in DNA testing, as opposed to the PGA subtype testing. Or they simply may have extrapolated what they knew was going to occur, DNA testing, with the information that had already been proven, the PGA subtype information, and extrapolated that out to likely DNA test results. Those explanations are far more reasonable than what the defense would suggest. And in order to meet the standard of reasonable probability of materially affecting the defense, I think they have to show something more than that. And it's important or instructive that even the defendants themselves, the defense counsel, up until the time where this court indicated that Ms. Savage would have to take the stand, have never taken the position that the sources are important, let alone critical or go to the heart of their claim. And Mr. Ullman repeatedly advised the court on Thursday that defense counsel does not believe that it needs to know precisely who the sources are of this information in order to establish their case. Given that, and given that it certainly is not direct evidence or even arguably reasonable indirect evidence of what the defense is, I think that they haven't met the threshold showing that the Delaney court established. But even assuming that the court found the threshold test had been met, which we do not believe it has been, then the court must go beyond that and look to the factors that the Delaney court identified and balance those factors and consider those factors before requiring the reporter to take the stand. There were 4 identified in the Delaney opinion, and we would submit that all 4 argue in favor of quashing the subpoena. The first is whether the information is confidential or sensitive. And the Delaney court recognized that on a sliding scale, when you're weighing a criminal defendant's Sixth Amendment rights, that non-confidential information may be at the bottom end of that scale, although they made a point to say that even in that case it may be protected. Sensitive information, which is not confidential, may be subject to greater protection, but the highest level of protection under the Shield Law is given to confidential source information, which was not at stake in the Delaney case, yet they took great pains to indicate that that is a distinguishing factor from the circumstances that were before the court in that case. Here the sources are confidential, and this factor heavily weighs in favor of quashing the subpoena and not forcing Ms. Savage to testify. I'd point out that the defense counsel did file a brief, although I think by error this was not filed with our office, but simply served on NBC's counsel, but I did have an opportunity to read it late last night. And they've misconstrued this factor as somehow being dependent on what the information is being used for. And they refer to a quote in the Delaney case about information being used to show corruption in government. But that was related to a different factor entirely. The Delaney court indicated that the first factor to be considered is whether it is confidential. And if it is confidential, that is an important factor weighing against forcing a reporter to testify. In the example of corruption in government, the Delaney court was referring to sensitive information that may not be confidential, but nonetheless should be subject to some kind of protection. The second factor the Delaney court recognized was what the interests are that are sought to be protected by the Shield Law, and whether the interest is mooted by something, for example, like the defendant himself being the source of information. And there's no showing in this case by the defense camp, who certainly would be aware of that if that were the case, that the defendant himself is a source of information. And that has been the case in other cases considering confidential source information, where reporters have gotten information from the defense or from defense counsel, and the defendant or his counsel have then tried to get the reporter to confirm what they had told earlier to the reporter. And under those circumstances, the Delaney court said that may be a different kettle of fish entirely. But that's not the case here. The defendants are not arguing that they need Ms. Savage to confirm information that they provided to her or something that Mr. Simpson provided to her. The policy of the SHIELD law is clear. It is to promote news gathering and dissemination of information to the public. And in both the Delaney court and a variety of other decisions in California and elsewhere, courts have recognized that it is critical to protect a reporter's confidential sources, and that policy, that important protection, should only be overcome in a very rare circumstance. So the second factor also militates in favor of a motion to quash the subpoena and against forcing Ms. Savage to take the stand. The third factor is the importance of the information to the defendant. The Delaney court indicated that even once the threshold is met, if the information is so critical to the defendant's case that he cannot have a fair trial without this information, then that may weigh even more in balance of the criminal defendant. But that's not the case here either. We don't even think the threshold has been met, let alone something that so materially would affect the defendant's case that he cannot have a fair trial if this information isn't provided. This is not an instance, as has been true in some other cases involving confidential sources, where the reporter is protecting someone who is an eyewitness to the crime, who could provide information that goes directly to guilt or innocence. This is so far removed from that, as Mr. Goldberg indicated in his argument last week, that this is 15 steps down the road from anything that would go directly to Mr. Simpson's guilt or innocence. The final factor the Delaney court indicated the court must weigh is whether there are any alternative sources for the information. And even though they did point out that this should not be rigidly applied, the Delaney court made clear that where, as in this case, the information involves the identity of confidential sources, that this requirement should be more vigorously imposed. And in the Delaney case, there were no confidential sources involved. It was a reporter's eyewitness observations. And so in that instance, they said that this factor does not weigh as heavily as it might in a case that involves confidential sources. This case does involve confidential sources. So this factor becomes even more important. And there has been no effort whatsoever by the defense to examine any witness on the stand about whether they were a source of information for Ms. Savage, to call any witnesses to the stand, to try to narrow the scope of people who might have been potential sources.
They didn't even ask
me. The defense
me.
counsel argued last week that there are a limited number of people that this could possibly include. And yet they've made no effort to examine any of those people to determine whether they were the possible sources. So of the four factors in this case, all four, we would submit, argue in favor of the motion to quash. And completely distinguishable from the result in Delaney, in this case, this is not a reporter's eyewitness observations. Confidential source information is involved here. It is a case where it does not go directly to guilt or innocence, whereas, as in the Delaney case, the reporter was, had been an observer of whether or not the defendant had given consent to a search. And if the consent had not been given, everyone agreed that the search would have been improper and only the search had led to the defendant's arrest. So there it directly went to the issue of whether the defendant was properly arrested or not. The final point that I would mention is that the defendant has submitted in their papers that he is somehow entitled to this information in order to present his defense, and that if he's not given this information, that his fair trial rights are interfered with. And they cite a number of cases where, depending on the circumstances, depending on the importance of the information, there has been some overcoming of a particular asserted privilege. But in both California and other contexts, in the Reporter's Shield law, California courts have consistently held the fact that there's some information that the defendant cannot get, for whatever reason, either because of a statutory exemption, either because of a California constitutional provision, as is at issue here, because of evidence code provisions like 352, like the hearsay provisions, that say there is some public policy reason why the defendant is not entitled to put this evidence on. His fair trial rights are not interfered with. And we can certainly cite to the court innumerable cases involving various privileges, involving various protections, and statutory policy decisions where courts have said the fair trial rights are not implicated simply because the defendant cannot get what information is he is seeking. But even to the extent that the court accepts the defendant's argument that he needs to be able to present an argument to the jury that the fact that Tracy Savage had a report in September of 1994 about socks, which had not yet been tested by DNA testing, that they argue this somehow furthers their conspiracy claim. They can make that argument to the jury, present the videotape, and make that argument without delving into Ms. Savage's sources for the information. They can argue that if they're knowledgeable sources, then that furthers their conspiracy theory, and the prosecution can argue that it does not.
When we talk about alternative sources for the same information, can you think of a plausible justification that I would allow a TV news broadcast to be played to the jury as evidence?
Well, Your Honor, in our personal view, my personal view, I don't think that the television broadcast is probative of any issue in this case. So I don't think there is a reason for the court to present the video
Well,
to the court.
let's try with something more fundamental like hearsay. I mean, how would that ever be overcome?
I'm not advocating that position, Your Honor, because I don't think that it is probative or that it does overcome all the objections.
Well, no, you offered that as an alternative source.
That if the court believes the defense argument and believes that they've overcome these objections and believes or agrees with them that this is probative or material information, then that's a separate issue entirely from whether the sources of that information are probative or material or relevant. In other words, the argument that they make, whether this somehow furthers some conspiracy, even if you assume everything that they say, and assume that this is material and important and that it did come from some high-ranking official somewhere, if you assume all of those things, then that's the source of the particular individual becomes irrelevant. But I agree with the court. I don't think it is probative of any issue. I don't think it's material to Mr. Simpson's defense, and I think it would simply serve to confuse the jury on a tangential issue and distract the court's attention by focusing on a whole panoply of witnesses and evidence and issues related to who Ms. Savage's sources were for this story instead of the material issues in this case. And I'm not aware of any case where a reporter has been forced to reveal confidential sources about an article which both sides have acknowledged, or at least the parties admit, was inaccurate as to the point that they say is important. So all the cases where a reporter has been forced to reveal confidential sources, and they are few and far between relative to the number of times that information is sought. But even in those few cases, there's no case that I'm aware of that even remotely is close to the circumstances in this case. And given the critical, I think the Playboy Enterprises case uses the word paramount interests that the voters of California expressed in enacting this into the Constitution, given that paramount interest, it's a very high standard that must be met. And I don't think that the defense in this case has satisfied even the threshold, let alone any of the four factors that argue against forcing Ms. Savage to take the stand.
All right. Thank you, counsel.
Thank you.
Mr. Ullman?
I think we're in agreement, Your Honor, that the guide for the court's decision in this matter is the Delaney opinion, and I think that opinion sets forth a very clear blueprint for the court to follow in addressing the issues that are presented. Number one, Delaney makes quite clear that we are not dealing here with a privilege, that we are dealing here with a immunity from contempt, and that immunity is a qualified immunity. So the existence of the newsperson's shield law presents no basis to quash the subpoena. In fact, Delaney indicates that the reporter initially bears the burden of proving that the shield law even applies. And I don't know that we're to that point yet. Ms. Sager assumes that, for example, the source in this case is confidential. We don't know that. We don't know what assurances or promises were given to the source in exchange for the information. It may have been that no such assurances were made and no promise of confidentiality was made to the source. The other thing that Delaney makes quite clear is that the shield law does not protect information that has been disseminated. And in that respect, all of what KNBC has already told us about their source points very clearly to a strong possibility that the source came from within the Los Angeles Police Department. And that, of course, is the important fact that the defendant is seeking to establish. The qualified immunity can be overcome by the defendant's right to a fair trial. And Delaney indicates that all the defendant has to show is a reasonable possibility that information will materially assist the defense. We believe that in the current juncture of the case, we already have enough information before the court to suggest a reasonable possibility that this information will materially assist the defense. Because we already know, for example, that the broadcast of this information on September 21st coincided with activity within the Los Angeles Police Department that would only be known to sources within the LAPD. That on September 18th, a PGM subtype test had been performed, that preliminary results had been obtained, and that apparently on September 21st, a decision was made to send the socks out for DNA testing. We also know that just 9 days before, cell mark test results were leaked on the same day that they arrived in a fax to the LAPD SID laboratory. Your Honor is also aware that as soon as Your Honor entered an order requiring that all test results be sent directly to the court, the leaks stopped. As soon as they stopped going through the sieve of the Los Angeles Police Department, the problem of leaking came to an end. We also know, and this is pointed out in Ms. Sager's moving papers, and I thank her for that other news media apparently who were reporting similar stories, although not reporting the false information that KNBC reported, identified law enforcement as their sources for the story. So all of these factors and KNBC's own revelations thus far about their sources point to the Los Angeles Police Department. Now, if in fact this leak came from the Los Angeles Police Department, there will be a strong inference to support the defendant's defense of evidence tampering in this case. First of all, we have within the Los Angeles Police Department sources confidently predicting results of tests that have not even been performed, suggesting that that confidence may have come from knowledge of the source of the blood that was being tested that would emanate directly from participation in the tampering or planting of that evidence. We also have a very strong motive to predetermine the test results. We also have very strong evidence that this investigation lacked objectivity. Time and time again, we've been treated to the prosecutors getting up and asking police witnesses, "You're not part of any conspiracy in this case, are you?" Well, what we have here is very strong evidence of a conspiracy to prejudice the defendant's rights to fair trial by leaking information during the pretrial stage at the very time that we were engaged in the process of selecting a jury in this case. And what more compelling kind of conspiracy could you have? And finally, if you put this all in the context of the SOX, that we are talking here about the leak of information related to the SOX in a context where we have already established discrepancies in the collection of that evidence in terms of the reported time that the SOX were recovered, discrepancies in the observation of blood, in which we were told that numerous criminalists did not see blood on the SOX until 6 weeks after the SOX had been collected, evidence of experts that the blood pattern on the SOX do not conform to blood splatter, but to the actual compression of blood against the sock, and testimony of experts that the blood stains contained EDTA that the sock itself did not contain. Now, all of that weaves an important web of evidence with respect to the integrity of the evidence collecting process and the possibility of tampering with that evidence. Putting direct evidence that the source of this news report came from the Los Angeles Police Department would not just present a reasonable possibility of materially assisting the defense. It would indeed go to the heart of the defense. And we believe that that provides a very compelling argument to overcome the assertion of the qualified immunity in this case. With respect to the balancing test that the Delaney Court set forth, there are 4 factors, as Your Honor is aware. The first relates to the confidentiality or sensitivity of the information. We have yet to hear any evidence that the reporter has the...
Well, Mr. Roman, let me ask you this then. Following your argument to its logical conclusion, assuming that I deny the motions to quash the subpoenas for Tracy Savage, she testifies, says I gave some assurance of confidentiality, and I now refuse to divulge those sources, and I claim immunity from the contempt sanction.
Mhm.
Let's assume that I make a further finding that I find the information to be material and necessary to Mr. Simpson's defense, and I invoke the contempt sanction. And let's further assume that I grant a temporary stay of that contempt citation so that Ms. Sager can run down the street to the Court of Appeal and file her emergency writ. And let's assume that Justice Turner has nothing else to do that day and has the opportunity to spend an enormous amount of time dealing with the issue. Let's assume all of that occurs. Is that really necessary? Because all you're really asking for is the opportunity to present to the jury that at the relevant point in time, this misinformation was reported.
Well, we're entitled to do more than that. I think we're entitled to do that. We're certainly entitled to present the misinformation that was reported, to present the explanation of the information that has already been publicly disseminated, which points to the Los Angeles Police Department. We're entitled to present the director of the LAPD laboratory to describe what was going on in terms of protecting this
Bye,
information.
Terry, love.
And then
Have fun
argue
at
to the
church.
jury an inference that there is tampering going on and that this information came from the Los Angeles Police Department. But what Ms. Savage's testimony would do for us would be to present direct evidence that it did indeed come from the Los Angeles Police Department, so we no longer have to rely on an inference. Because you can bet that the prosecution will argue against that inference. They will say, that's not a fair inference to draw from this evidence, as we heard last Thursday. It could have been a lucky guess. It could have been that they were relying on some interloper or some flake to present this information to the public. So we'll hear that argument. But by cutting through the assertion of qualified immunity, we don't have to rely on an inference. We can present direct evidence that indeed this information did come from the Los Angeles Police Department, which is very compelling evidence that goes to the heart of our case.
I think the strongest point that you make inferentially is that once the court ordered all test results be directed directly to the court rather than to the investigating agencies, and all of this nonsense stopped.
I think when we talk about, balancing the public interest in this case, I think that's very important to bear in mind, that we are not talking about the access of public to information that would never otherwise be disclosed. All that we're talking about here is the interest of a court in preserving the right of the defendant to a fair trial until a jury has been selected. And what was going on here was a very deliberate attempt to subvert that process simply by giving the media advance information at the time when it would prejudice the defendant's rights. We're not talking about information that would never be disclosed. In fact, this information has now been disclosed in this courtroom in the orderly process of law, which is when it's supposed to be disclosed. So all we're talking about here is some news agency somehow getting an edge so that they have an exclusive that can severely prejudice the right of the defendant to get a fair trial, to get jurors who have not been prejudiced by information that the court has a right to control, to prevent its dissemination until the time is appropriate. There's one other aspect with respect to this matter with regard to alternative sources, and that is we are informed, although we have never been provided with any of the results, that an internal investigation was conducted by the Los Angeles Police Department. So there was an alternative pursued to attempt to identify the source within the LAPD by an internal investigation. If the results of that investigation have been turned over to the prosecution or to the court, they have not been turned over to the defense, and we think that information may be relevant and helpful to the court in resolving the issues that are presented by this motion today.
All right. Thank you, counsel. Mr. Goldberg, do you want to address any of the materiality argument raised?
Yes, Your Honor, that is the only issue that I did want to address. Because, as I said, I don't think that the people have a direct interest in the balancing part of this equation. But let me just say this, that in addition to the threshold standard that's articulated in Delaney, requiring that the defense show a reasonable possibility that the information will materially assist his defense, that's at page 808, that there is an independent legal theory to look at this issue of quashing the subpoena, and that is that you always are going to have to show, in an instance where a motion to quash has been made, that the witness in question has some material evidence to give, because we don't allow people to run around subpoenaing individuals that do not have any material information to provide in a given case. So independent of the legal theory that's articulated in Delaney, the court would always have to look at the issue of relevancy and materiality of a witness in determining an issue to quash. But the two obviously are very closely interconnected, the standard of relevancy and also the Delaney standard involving materiality. On page 6 of the defendant's points and authorities, they articulate what I think we can characterize as somewhat of a laundry list as to possible relevant purposes or material purposes for this kind of evidence, and I'd like to go through them. I've addressed some of this previously on Thursday, and I'll try not to repeat what I said to Your Honor at that time. On the second full paragraph starting at line 13, they say that for persons who are directly engaged in the handling of evidence, to leak the results of tests before the testing has been completed creates a strong inference of illicit tampering with the evidence. So that's one theory. It's the tampering theory. I'd suggest it's really the only theory that should be under consideration by the court at all. But what I would point out about the way that the defense articulated this is they themselves have pointed out that the only conceivable way that this could be relevant or material is if someone who was actually involved in the testing, according to the way that they've phrased it, was responsible for the leak. Because obviously if we had a situation where it was someone at robbery homicide who overheard a conversation, or someone in the prosecutor's office, there's no conceivable way we can even articulate a theory under which that leak would be relevant, and I think the defense acknowledges this. So the issue then becomes, Your Honor, if someone who was directly involved in the testing themselves was in fact the individual who was responsible, if there was an individual, for the alleged leak, how is that relevant, or is that at all relevant for the purposes of this threshold requirement that the defense must make. And we say that it isn't. On Thursday, I articulated two different ways that the defense could contend that this is relevant. One, they could suggest that the news report motivated the individual that tested the evidence to plant evidence. That is not the theory that they are articulating, and Mr. Ullman specifically rejected that as a theory. I think this is important to try to force the defense to be analytically precise in what their theory is, because in doing so, then we can determine whether there's any merit to it. So we can slowly begin to chip away at what they're not contending so that we can focus our attention on what they are contending. For example, on Thursday, I pointed out that the evidence that the defense claims shows that the socks were not present in a photograph that was taken supposedly before Mr. Fung collected them, that evidence was not relevant to the issue of planting. And Mr. Ullman conceded that that was true, and so that only was relevant to the issue of whether or not the evidence was properly handled. In other words, that it went more to unintentional mishandling of the evidence, because it was not reasonable to conclude that blank socks themselves were planted and that subsequently evidence was planted on those socks. So I'm just trying to point out to the court that by trying to force the defense to articulate precisely and clearly what their theory is, only then can we then be in a position to determine whether or not that theory has sufficient probative strength and whether there's any evidence to support it for the purposes of this threshold requirement. So what their theory appears to be is that the fact that someone, or if someone who was connected with the testing of the evidence leaked evidence regarding the socks, that demonstrates or tends to demonstrate that evidence was planted on the socks prior to the time of that leak. And the reason that we say that that theory does not make sense and is illogical is because one cannot conclude reasonably that an individual that was responsible for testing these socks and knew that the evidence was planted then decided to disclose that knowledge to the press. It is counterintuitive, as has been argued. And in fact, if such a leak did occur, that fact would tend to exonerate the individual, because the logical and reasonable argument would be, why on earth, if I in fact planted evidence on the socks, would I then do anything that might have the tendency of giving myself up, such as contacting the media and saying that there are test results that have been performed on these socks. It is not reasonable to believe that this individual would do that. It is not a logical and believable argument, and therefore the defense theory that this logically relates to the issue of planting should be rejected. Now, in addition to that particular theory, the defense has two additional, what I would characterize as throwaway type theories of relevance, perhaps seeing the weakness in the first theory. The second one is, they say, I'm quoting from the same page, page 6, that this evidence is, quote, direct evidence of examiner's bias, end quote. Well, the LAPD didn't do any of the DNA testing on this case, so there's no logical argument that this in any way relates to examiner bias, and they don't attempt to articulate how it does relate to that issue. And then thirdly, they contend that this is relevant to a rush to judgment. But I would state, Your Honor, that the issue of rush to judgment itself is not relevant, because the subjective beliefs of the law enforcement officials, the DAs that are involved, the deputy DAs that are involved in prosecuting this case, and the detectives that are involved in prosecuting this case, whether they subjectively believe the defendant is guilty, and if so, when they form that belief, is not a relevant issue. It never is in a criminal proceeding. And somehow this has been allowed to have been introduced and interjected in this trial as a spurious non-issue that has no real evidentiary significance. But even if it did, I don't see how this leak in any way relates to the issue of rush to judgment, or the non-issue of rush to judgment. So if we go through the defense contentions and we carefully look at them, it does not appear that there is any theory under which it would be relevant. And clearly there is no evidence to support any of those theories, and apparently they must produce at least some evidence, because according to Delaney, mere speculation itself is not sufficient to meet this initial threshold requirement. And therefore, Your Honor, we contend that the threshold requirement has not been met. Now, in addition to this issue, I'd like to address briefly the question of whether or not the report itself is hearsay, and I don't want to do that at length, because I think the court has already impliedly indicated through some of its comments that the news report itself is clearly inadmissible hearsay, although the court argues to the defense argues to the contrary.
Well, let's not get to that issue yet. We're not at that point.
All right. And finally, Your Honor, as to the issue of the internal investigation, the defense was aware of the internal investigation, because it was mentioned on the record, and I believe even requested by defense counsel at the time that this issue was initially addressed by the court on September the 22nd and 23rd, where they suggested that an internal investigation should be conducted. We do not have the reports from such an investigation that I am aware of, and I do believe that they never did pinpoint what was the source of the leak, so there isn't any information that the people are aware of any value as a result of that investigation. If the defense wants those materials, then there is a way of getting materials, and they have to use the procedures that are required under a pitches type motion to get those kinds of internal LAPD documents, and they can file that kind of a motion if they want to. But in the absence of the procedures that are required under pitches, they are not entitled to that kind of information.
All right, thank you. Ms. Sager? Briefly.
I just want to respond briefly to a couple of points made by Mr. Ullman. First, with respect to whether a motion to quash is appropriate, he indicates that because it's not a privilege by an immunity from contempt, that somehow this is not the correct procedure for the court to adopt. But whereas here you're involving a non-party, contempt is the court's only remedy. And in that instance, the California Supreme Court has said, and for example in the New York Times versus Superior Court case, that it operates as an absolute privilege if contempt is the only remedy. So it operates in the same effect as a privilege, and a motion to quash is appropriate. And in fact, that is the way that most courts in California have reached this issue, through a motion to quash a subpoena or a motion to quash a seeking of testimony from a reporter. So I think the court certainly can use this procedure to rule on these issues, and we hope will accept the motion and quash a subpoena. He raised
Mr. Ullman's point that the record is devoid of any evidence, as opposed to proffers of counsel, that Ms. Savage is in fact a news reporter covered by this particular statute, that she is in fact the person who participated in the reporting that is in question, and that she gave some assurance of confidentiality to the sources of that information. Isn't the record completely devoid of that?
Well, Your Honor, I was about to reach that issue, and it certainly has been represented by counsel, and until this point in time, it wasn't, to our knowledge, there was any question about any of those things. And we would have been happy to submit, and still would be happy to submit, a declaration from Ms. Savage covering those points, indicating, as I think was indicated in our brief, that she is in fact a reporter for KNBC Television. She was acting in that capacity when these stories were broadcast, and that the information for those stories came from confidential sources, individuals to whom promises of confidentiality were made. And we would be happy to do that. I don't think it's appropriate to then conduct an inquiry into her other information in order to have that information before the court. We can have a declaration here before the end of the day that sets forth that information if there's any question about it. And to this point, there never had been, and at least at the hearing last fall when this issue came up, it was represented, and counsel all seemed to agree that that was the case, and that the issue was whether or not the privilege would be overcome. But we're happy to provide a declaration to the court containing that information. Now, Mr. Ullman suggests, I think mistakenly, that the only issue is whether this information materially assists the defendant, and as is clear in Delaney, that is only the threshold. And I agree with Mr. Goldberg, and based on the information argument I've previously presented, they have not come close to meeting that threshold test, let alone exceeding it. But even if they did exceed that threshold test, which I think they clearly have not, then the court looks to the four factors in a balancing equation. It simply doesn't say, okay, the reporter now takes the stand. We've determined that it materially impacts the defendant's case. And as to the four factors, there's been no showing that those factors militate in favor of forcing Ms. Savage to testify. And with all due respect to Mr. Ullman, most of what he presents is irrelevant to that issue. What other media reported has nothing to do with what Ms. Savage's story was about or who her sources are. Whether or not there's other evidence of a conspiracy has nothing to do with whether this particular information, the sources of information for her news reports, goes to that issue or is material to that issue or significant or substantial, as that term is defined. And the court in Delaney made clear it has to be something more than speculation, more than a chain of links in a chain of hypothesis or speculation in order to satisfy the materiality and reasonable possibility standards. And that showing hasn't been made. And the court, I think, correctly indicates that if what they want to present to the jury is their argument about this being a Lincoln conspiracy or that there was inaccurate news reports, Mr. Ullman last week said repeatedly to the court, we don't need the sources of information for that. And somehow they've gotten the light or changed their position or something in the space of the last couple of days to now say this information is somehow critical, when he repeatedly represented to the court that they didn't think it was critical and in fact was irrelevant to the argument they wanted to make. But I'd end with simply saying that there is no case that I'm aware of, certainly none cited by defendant, where anything closely approximating these circumstances has resulted in a reporter being forced to divulge confidential sources. No case that I'm aware of where a reporter has been forced to reveal sources based on a news report that the parties say was inaccurate. Certainly not in the context of a criminal case where you have a defendant presenting an argument. This does not go directly to the question of guilt or innocence, or is not directly evidence of any kind of conspiracy, but is simply a series of innuendos or speculation or hypothesis. And for all those reasons, I think that the privilege has not been overcome in this case, and it would be improper for the court to force Ms. Savage to testify and ask her to reveal her confidential sources.
All right, Mr. Ullman, do you have any brief response?
Very briefly. I just want to make 3 quick points. Number one, Mr. Goldberg suggests that somehow we must articulate a theory of when the blood was planted on the sock in order to establish the materiality or relevance of showing the source of this leak. The problem, of course, is the sock was in the exclusive control and custody of the Los Angeles Police Department from June 14th until September 26th, when it was sent out for DNA testing. So we don't know at what point the evidence may have been planted. And the problem, the real issue in this entire question is whether we should have confidence in the integrity of the Los Angeles Police Department in maintaining the custody and control of that evidence. And what we're dealing with here goes directly to the heart of that question. How much confidence should we have in the integrity of those who were entrusted with the care and the control of this evidence? There are a number of inferences that arise. A possible inference of planting of evidence, a possible inference of examiner bias, a possible inference of a conspiracy to prejudice the defendant's right to a fair trial. But until we know who the source of this information was within the Los Angeles Police Department, we can't pursue where that takes us. Once we identify that source, then we know where we can go to clarify, to provide the information that both this court and the jury are entitled to in terms of resolving this very difficult issue. Secondly, Mr. Goldberg makes the point that there was an internal investigation that apparently came up dry, but the only way we can see that is to file a Pitchess motion. We would respond, first of all, if an investigation came up dry within the LAPD, that goes directly to Your Honor's resolution of the question of whether there's an alternative source other than ordering the reporter to reveal the source to find out who that source was. And the fact that the LAPD has internally investigated and been unable to identify the source would, I think, be very useful to the court in addressing that issue. And we believe the court has power to simply order the production of that report for purposes of this hearing in the exercise of its inherent power.
I don't think I can do that, given the very strict language of the evidence code after Pitchess that indicates this is the exclusive manner in which these types of records are to be sought.
But a Pitchess motion requires us to make a specific showing that information about a specific officer is relevant to our case. Here we have an investigation that did not apparently implicate any officer. And what its relevance is simply the fact that they made that effort and they were unable to determine what the source was. So we're not really using it for a Pitchess purpose of attacking the credibility of a police officer, but simply showing that the investigation had a negative result. And that's what's relevant to this hearing. Finally, I want to make clear, Your Honor, that what we would propose to do is to call Ms. Savage in the event that she invokes the limited immunity and establishes that the immunity applies before Your Honor applies the balancing test to determine whether to order her to testify. We would like an opportunity to call Michelle Kessler, the director of the laboratory, to further our showing with respect to the relevance and materiality of identifying this source. Yes, that would be outside the presence of the jury as well.
All right, I take it that then you're declining Ms. Sager's offer to submit a declaration by Ms. Savage regarding the foundational issues?
Yes, Your Honor, we would like Ms. Savage to testify.
All right. Ms. Sager, do you want to address that one specific issue?
Yes, Your Honor. In the context of a motion to quash, I'm at least aware of no authority that suggests that a reporter needs to personally take the stand as opposed to submitting by declaration form information which is merely foundational. And in this case, and as in other cases that I'm aware of, the court has accepted a declaration from the individual simply establishing foundational facts. And unless the defense counsel has information which would tend to cast any kind of doubt on any of those foundational facts, and given that the subpoena in question was accepted by KNBC's counsel at the defense counsel's request, I don't think that there is any question about her employment, about the context in which this information was gathered, and certainly I'm aware of no information which would suggest anything to cast into doubt her representation that the information came from sources who had been promised confidentiality. So absent all of those factors, and in light of what Other courts in California have adopted as the correct procedure to determine these matters on a motion to quash. It's simply the same as any other discovery motion where the court can take evidence and make a ruling based on evidence before the court. Does not need to be in testimonial form, certainly can be in declaratory form. And the only reason to not do it that way would be if there is something that would tend to cast doubt on information in that declaration. And absent an offer of proof by defense counsel suggesting that information exists, then I think a declaration would be appropriate. And to force Ms. Savage to take the stand would not be an appropriate exercise of the court's discretion.
Fine. Thank you, counsel. As to the motion to quash the subpoena for Tracy Savage, the court will deny that motion for the following reasons. The offer that has been made, the preliminary offer that has been made by the defense is sufficient for the court to go forward to at least establish foundationally that she is a news reporter and that her sources as to this broadcast, this specific broadcast, were to be held in a confidential manner. I think that has to be established on the record and subject to cross-examination. So to that extent, the motion to quash is denied, and I'll grant the defense the opportunity to call and question Ms. Savage as to those issues. If, in fact, after being asked, will she reveal the sources of those, that information, and if she invokes the SHIELD law and indicates that even if the court finds her in contempt that she will not reveal those sources, then the court will go into the other issues suggested by Delaney. And if that occurs, this is a rather complex issue that I will not probably be able to determine today. All right, Madam Reporter, what's your status? All right. Ms. Sager, do you want to confer with your client before we proceed? All right, we'll take 10.
Oh, no, we won't. We will take 24 and 10.
Present.
Okay, not 24, because that would put us at 8:30 tomorrow, which would be very, very late. People would be very, very angry. There would be chaos. All 7 of you would go on strike if I started OJ tomorrow at 8:30. But I'm not going to. Don't worry. I'm going to start it normally, like I normally do. All right, guys. Tomorrow, you're not going to believe this. I'm going to tell you something, and you're really just not going to believe it. Tomorrow, we're on video 378. Oh, man. And some of these videos coming up are little. Like 40 minutes instead of 2 hours. Some of them are 14 minutes, 30 minutes. So we really, in a week or two, should hit 400. And then we're at the home. We are on the home stretch, and there are some tiny videos in the 400s. There's a 4-minute, there's a 6-minute, there's a 50-minute, a 40-minute. They're not as long. We have a larger amount of small videos. We still have 2-hour videos in there, but we have a larger amount of small videos. So once we get, ooh, I see a red one. That's the one I need to get. That's the Furman one. All right, 425. Video 425 is when I need to have my bleeper finger really ready. We are on 378. So I'm getting close to the Furman one. It's alright, I have off for 5 straight days, so I can do that now. I hope you guys have a great day. Thank you so much for coming out. I really appreciate it. Be good today. I hope to see you all tomorrow. Thanks, guys. Bye.